latest in our series of webinars on issues surrounding women's rights in healthcare. For those of you who don't know me, I'm Angharad Vaughan, a partner in the medical negligence team at Leigh, and I've acted for many women in claims arising from failures in maternity services. The topic of today's discussion is politics, the law, and the right to choose. Abortion is an aspect of healthcare which divides opinion. Providing high quality care for women and clients relies not only on best clinical practice, but also on ongoing work in Parliament and the courts. 2020 has seen significant changes to abortion law and provision across the UK. This session will examine how these changes happened, the impact they have had, and the interplay between politics and the law in protecting, defending, and advancing women's rights and reproductive health. We've got three expert speakers to lead the discussion. We have Stephen Hall, political advisor to the President and Chief Executive of the RCOG. Stephen is the lead for abortion care at the RCOG and is responsible for advocating for high quality services and a legal framework consistent with the RCOG's ambition to decriminalise abortion. This involves working closely with clinicians, governments, politicians, advocates and journalists to address the many challenges to abortion in the UK. Stephen also works closely with the RCOG's Centre for Women's Global Health to advocate for safe abortion and post-abortion care services around the world. We also have Rachael Clarke, a public affairs and advocacy manager at the British Pregnancy Advisory Service, or BPAS. Rachael works with clinicians, advocates and politicians to campaign for reproductive health and rights across the UK. She has a background in politics, working in and around Westminster for 6 years before joining BPAS. In her role, she's written parliamentary bills and amendments, briefed parliamentarians, worked with journalists, helped change the law in Northern Ireland, the Isle of Man and Guernsey, and run the campaign to introduce buffer zones around abortion clinics. And finally, we have Jude Bunting. Jude is a barrister at Doughty Street Chambers. He specialises in judicial review, human rights and media law. He's an expert in arguing novel and high profile points of law and has acted in 15 cases before the Supreme Court. In 2020, Jude was named Public Law Junior of the Year at the Legal 500 Bar Awards and Lawyer of the Week in the Times. He is called to the Bar of Northern Ireland and is a member of the Equality and Human Rights Commission Panel of Counsel. He has acted in many of the recent abortion rights legal claims. So without further ado, our first speaker is Stephen Hall. Stephen, over to you.
Thank you, Angharad. I have to say, Jude has definitely won the best background of today's speakers. Look at that, incredible. But thank you very much for inviting me. I've got the privilege to go first. So I'm going to, I think, touch on probably all of the elements which are involved in today's webinar. The first is obviously healthcare. So believe it or not, this is even contested by some people. At the RCOG, the Royal College for Obstetricians and Gynecologists, we believe that abortion is healthcare, but many groups do not. They consider this a relationship between two individuals. So I'll briefly provide an overview of RCOG's stance on abortion. The law, well, I think Jude will probably cover a lot of this in how the law weighs in on abortion in the UK, and obviously the political situation, given the fact that abortion is very much determined by statute law, by primary legislation. So I will try and go over that as well. I'll also try and keep to 15 minutes, so I'll try and stop speaking at 20 past. Thank you. So in terms of what the RCOG is, I know many of you may not be aware about what the organisation does. So we're essentially the professional body that represents obstetricians and gynecologists, who are predominantly the doctors involved in providing abortion care services in the UK. So as an organisation, we do lots of different things. We provide training, education, examinations. We also produce clinical guidance. CPD, we have many sort of quality and improvement programs, but we also do global health projects. And I'm in the policy and the public affairs team at the RCOG. So we do try and advocate for what we as a professional body believe is the best for women, and obviously reproductive rights is clearly on the agenda. So in terms of clinical guidance, we've got 3 fairly authoritative pieces of clinical guidance around abortion. The first is the 2011 Care of Women Requesting an Induced Abortion. Last year we had the 2019 NICE guidance on abortion, which was co-badged with the RCOG, which was a really great piece of guidance, because it's fantastic to have somebody like NICE publish guidance on abortion care, and really advocate for things like minimal delays for services as well. So making sure that guidance that clinicians receive provides care which is in the best interest of women. Clearly, COVID has had a huge impact on abortion in the UK as well. So Rachael, I think, will talk about how it's changed after me, but the RCOG did produce coronavirus and abortion care guidance, which recommended a new innovative model of care, which was based around telemedicine. That was published earlier this year at the height of the first wave. So really my role at the RCOG is to support our clinical leaders. It's to help them negotiate what is a very complex health landscape. Obviously, all health services are heavily regulated. When it comes to abortion, we don't just have regulation, we've got primary legislation to deal with too, which brings in the sort of nature of politics, where the Secretary of State does have quite a large amount of power when it comes to certain aspects of abortion care in the UK. So really what I see my role as is one of the conduits. I work with a team of people between our sort of members and fellows, but also with the politicians, the government, media, health system, etc. It's an interesting job, which I think I could talk more about, but essentially involves how we consider strategy. So if we've got a particular issue to consider, like abortion, and Karen mentioned that the RCOG supports decriminalisation of abortion, which is true. So how do we make sure that becomes a reality in the UK? How does the political context affect how we deliver that ambition? And then how do we deliver it? How do we actually move forward? One of the things we've been really successful at, I think, at the RCOG is using the organisation to really convene lots of different stakeholders who are interested in abortion care and who have a stake in abortion care, to what we call the Abortion Task Force. This was set up in 2015. It involves clinicians, involves the government, different Royal Colleges, different medical professional bodies, organisations like BPAS, which Rachael is here to represent today. And it really is there to discuss some of the challenges which are involved in providing abortion care in the UK in 2020. And there are a number of them, but obviously, we're focusing today on how legislation really can affect how care is provided. What does decriminalisation mean? It's kind of a bit of a nebulous term, I think. So the RCOG supports really removing abortion from criminal sanctions. So making sure that the law is there not to punish women, but to support them. And to allow, obviously, healthcare professionals to provide the best care that they possibly can without a overly restrictive law. Many of you will know, I think, that the current legal framework in the UK is quite complex when it comes to abortion. So the primary legislation which governs abortion is the Offences Against the Person Act, which is 1861. So that was Palmerston's government who signed that act. It was at the height of the British Empire. it's therefore had a significant impact actually on former colonies in this area too. As a bit of background as well, it was also interestingly signed a few months after the cessation crisis in the USA, which precipitated the US Civil War. So that gives you a bit of an idea about how old this law really is. And this is what really governs the Abortion Act. This is really what governs abortion care in the UK, in that abortion remains a criminal act, apart from under separate grounds and circumstances, which was introduced in 1967 by the Abortion Act. And the Abortion Act really talks about the grounds and the exceptions for when an abortion is not criminal. So the various grounds under which you can have an abortion. It also talks about place. So where can you have an abortion? And it talks about who can really provide abortion. So at the moment, abortion care has to be signed off by 2 doctors, which can present some challenges because the vast majority of the workforce involved in providing abortion care is usually not doctors, but midwives and nurses. So really, we're in a situation where 1967 is quite a long time ago now. This is one of the problems with with a legal framework which has such an impact on current practice, because it quickly becomes outdated and it stifles innovation. So that's something that we have to consider. It's also devolved in the UK, so we have to be quite clear about what we're talking about sometimes. So different pieces of legislation will affect different regions. What do we believe at the RCOG? So we believe that fundamental to abortion is the definition of abortion as healthcare, which I touched on earlier. If we're moving towards decriminalisation, then we can't forget that, like all areas of healthcare, it's a heavily regulated environment. So this is not to deregulate; it's just to decriminalise. And like I said, we really want a law which protects women and doesn't criminalise them. And I think we probably all recognise that criminal sanctions bring with them a certain degree of stigma too, which is a real issue with abortion care. And really, we want to start making sure that women can access services without necessarily the stigma attached to them, which is a problem. But we have seen some really progressive movement. I'll come on to how we sort of get to this sort of picture, but since 2017, we've seen a huge shift in support from members of parliament towards the decriminalisation of abortion. So back in 2017, I think I've got a figure here. So we had only 28% of MPs in favour. Now we've got something like 50%. And then we've got the undecideds, and then we've got the sort of the anti-decriminalisation MPs too. So we've really moved and we've really shifted the dial in Parliament, where we can start to consider how we change that primary legislation, the Offences Against the Person Act, to make sure that women aren't criminalised. That's really the ambition. How do we get there? So it's been quite a journey, I think. The main thing we need to do is consider what we want to achieve. So like we've said, decriminalisation of abortion is the ultimate goal. We need to identify our legislative framework. So in this instance, let's talk about the UK Parliament. We need to consider part of my job is to consider who's our allies, who can we count on? And also, who can we count on in Parliament? So do we have the votes to get a sort of a bill over the line which decriminalises abortion? And then we have to understand, what our role as the RCOG is in this. We're obviously the voice of professionals who are involved in providing these services, but there are many other voices which really need to push out, not least the women who have abortions as well. The most important thing, which I always stress to when working with clinicians who are often very reasonable people, is that really you can't give any quarter to the opposition. So I'll come on to this in a minute or so, but we're in a situation where the opposition is often extremely anti-choice groups who will tell mistruths about the nature of abortion care, and they will never be reasonable with us. So it's my approach that we shouldn't offer any quarter to them. We always have to advocate for what's best for women. And so we shouldn't be compromising on our sort of stance on abortion care. I'm going to share my screen now, actually, because this is probably a bit of an example of some of the things that we see with the opposition. So I hope everybody can see that. Angharad, is that working? Perfect. So I'm just going to go through a few slides of the things that we often see when we're talking about this issue. And I think the thing to remember is that because this is such a political conversation, because ultimately it comes down to MPs who will vote in Parliament on this issue, that this is the sort of messages that they're sending out. The first is Act Now to Stop DIY Abortion, which killed 2 women. A complete untruth. There's no truth to that claim whatsoever. Absolutely untrue, but prominently takes center stage on their website, included in template messages to members of Parliament. So really scare tactics are used. The second one is, we care about women, against the campaign to decriminalize abortion. I mean, to me, it just doesn't make any sense. Maternal mortality prior to the Abortion Act, because of unsafe abortion, was something like 10–15%. So it's really untrue to claim that when you're against abortion, you're caring about women. We know that when you restrict abortion care, actually what you do is you just force unsafe abortion, which is obviously why we have that maternal mortality rate. Some other slides, which I hope I can go. Here we go. So abortion discriminates the anti-male nature of abortion. The court refuses evidence of DIY abortion killing mothers. This is again the same argument that DIY abortion has killed two women. It's just completely untrue. And then third, BPAS, sorry Rachel, offers abortion for women to achieve a summer bikini body. Completely untrue. If you read the transcripts for those consultations, which that claim is based on, it's just not true. Other comments that we get from these groups, they'll stand behind people like Putin. They've stood behind the recent legal action in Poland. They will claim that censorship zones will affect women and deny them emotional and practical support. These are the people who stand outside abortion clinics, shout and scream at women who are going in. And obviously the last one is quite horrible, really, comparing abortion to genocide. So this is just an example of the things that we often consider. And the other side of the argument, which is often why I say we shouldn't provide them any credence, because usually it's based on lies. Recently, we've had the Court of Appeal case around telemedicine, which Rachael and Jude may talk about, but essentially they've lost a series of cases in the High Court and the Court of Appeal this year around abortion. So there is this legal aspect that we are often working on too, where sort of fairly spurious judicial reviews are taken, which then have to be defended against. I think part of our job as well, if we consider decriminalisation, it's exactly how we secure that. So what do we do when we need a bill? So Rachael and I are often in conversation around what's the best way to use Parliament to achieve the ends of decriminalisation. We need a fitting bill. There's currently a number of bills in Parliament at the moment which will decriminalise abortion, but they're all the wrong type of bill, unfortunately. They don't have the time to pass through all the stages of Parliament. So what we often need to do is strategise about how we get the right type of bill. Abortion is a conscience vote in Parliament, which means that governments can't whip against it. But it also means that any change really has to be brought from the backbenches. So we have to build support through that way. And the biggest hurdle really for decriminalisation, so the numbers are sort of in our favour. Most MPs do back decriminalisation. It's just attaching the right bill to that movement, which is often the problem. The ballot bill is the best way to do it. Ballot bill is, at least after the state opening of every parliament, there's the ballot, which private members, which essentially backbenchers can enter the ballot, and they can bring forward a private members bill, which will have time associated with it, so you can advance through those stages of parliament. That's kind of the tactic that we're trying to pursue. You can also amend bills, of course. So we saw this in terms of Northern Ireland. That was through an amendment. It's not always considered the best way to make law because it can be fairly rushed, but in this circumstance, it was definitely necessary. We've made a lot of progress so far, I think. So, you know, I told you the numbers about MPs who are supportive, but we've also got a wide range of support among professional bodies. So other organisations who support the decriminalisation of abortion include the Royal College of Midwives, groups like the BMA as well. So really high profile groups of healthcare professionals do back this because it just takes out the unnecessary and outdated regulations and legislation which govern abortion care and allow doctors to and other healthcare professionals to innovate like all other healthcare services, something which is really held back by primary legislation sometimes. I think we've also seen the Northern Ireland changes recently. We've seen legal change in Guernsey. There's a referendum in Gibraltar coming up around abortion care, which is very tightly regulated there. And recently the government have announced a consultation on the use of telemedicine. So I referred to this earlier and Rachael will talk a bit more about this, but essentially allowing telemedicine to be a permanent feature of abortion care in the UK, which has made some real clinical differences, improving safety and effectiveness. So we're hoping that we can make the case and argue for that change to become permanent. I think this is all in reach. When it came back, when it came to the 67 Abortion Act brought by Lord Steele, that was a ballot bill. It didn't have government backing originally. The RCOG led a commission to advise on that bill. The government then backed the bill and it achieved royal assent in 67. So this has all been done before, and we're very confident it can be done again. But most importantly, you just need to get a ballot bill, and that's just about getting lucky, really. You just need somebody to come top of the ballot who's supportive, and then you can have the time in Parliament for a proper debate around this issue. It's been so many years now since 1967 that the time is really due. Until then, I think the RCOG will keep up pressure. We're going to use our voice as healthcare professionals to advocate for the reproductive rights of girls and women. And, we'll win the smaller fights, we'll win telemedicine, hopefully, and we'll move forward and we'll finally get a bill which is able to go through. So that's kind of where we are. I'm aware I've gone 5 minutes over. I was going to, as a bit of a bonus, talk about America, but I think maybe if we've got time, there might be a conversation later around what some of my policy and public affairs colleagues in America might be doing at the moment, given where the election is, given the Supreme Court makeup. But if we've got time, maybe we can talk about that later. But I'm very happy to answer any questions, but I will hand back to Harriet now. I think we're going to move on to Rachael. Thank you.
Thank you so much, Stephen. That was really fascinating. What we'll do is we'll hear from Rachael and from Jude, but please do submit any questions that you'd like the speakers to answer using the Q&A box at the bottom of the screen, and we'll then deal with those at the end of the session. So without further ado, I'm going to hand to Rachael.
Hi, I'm going to start off by saying on a pretty regular basis now, my internet does a thing where it says it's really unstable. So if I freeze, don't worry, I will come back almost certainly. Fingers crossed. I actually have got a few slides. I thought about doing it without them, and I was like, you know what, actually, I'm quite a boring person. You probably would prefer the slides to me just by myself. Plus, there are quite nice bubbles on here, which I enjoy. And I think, as Stephen really said, like a lot of the stuff that happens with abortion, as much as we want it to be about healthcare, as much as it should be about healthcare, is actually about how politics works, how the law works. And like when it really comes down to it, parliamentary procedure and how much time there is to discuss it. And, you know, surprisingly enough, in the past few years with the discussions around Brexit, there hasn't been a huge amount of parliamentary time or inclination to spend getting into sort of a really meaty, difficult topic like abortion. So, you know, the minute that that happens, the ability to improve the care that's given to women is, you know, it's pretty minimal. And I think that one of the most important things actually that's happened really over the past 50 years since the bill was passed was actually this year with the change in the home use of mifepristone. And I'll cover what that is in a minute, because I imagine some of you aren't aware of how abortion services work. But really what the fundamental basis of what this did is it allowed telemedicine. For the first time, it allowed women to take safe and effective abortion medication in their own home. And that's something that up until now has not been clinically wrong, but has been legally impossible. And I think that really is the situation that we're in with abortion, that unfortunately there are many things that we would want to do to improve the care of women, to improve the experience that they have. And we just can't do it because of the legal situation that we're in, which is more than 50 years old. So I'll skip through these a little quickly. I thought that I would cover quite briefly the key players, but I think I should probably start by saying this is all about early medical abortions. So early medical abortions are 2 sets of pills. They are taken in the first 10 weeks of pregnancy, technically 9 weeks and 6 days. Up until this point, women had to take the first pill in a licensed premises. And a licensed premises is an NHS hospital or a clinic that's licensed for that specific purpose by the Department of Health. So you can't go to a GP surgery, you couldn't do it in your own home, you couldn't do it in a sexual health clinic. They were only very specific, limited circumstances. You had to take that one pill on the premises and you could take the rest of the pills home with you. But even that was a big step forward from where we were 5 years ago, because that law only started to be changed at the end of 2017. And up until that point, women had to take all the pills in the clinic and then try and get home before they started to miscarry. And that was entirely a legal provision. It wasn't anything to do with medical care. Experiencing these horrible symptoms of miscarriage while they're on trains, while they're waiting for buses, while, you know, for women from Northern Ireland, they're coming over on planes. And actually, you know, really they should just be able to take it at home. It's safe and it's effective and it's clinically fine, but legally we weren't allowed to do it. So this change, revolutionary, is how I've heard quite a lot of doctors describe it. I think it's been a really positive move, but you can sort of see how we got there, because it was not without its challenges. So the key players, Matt Hancock, who I think everybody probably knows. I particularly enjoyed this picture of him, this sort of little, I don't know, triptych, collage. It was about a week after he got diagnosed with COVID and then turned up, and that is the chief nursing officer for the UK, who was for England, who was sort of stood there looking on in horror as he coughed his way through his speech. So he used to have an app called the Matt Hancock app, which a bit like Grindr, but with only one person, which I think is a horrifying description. Unfortunately, a lot of his decisions on abortion are determined by the fact that he still thinks that one day he might get to be Prime Minister. And in the Conservative Party, that means don't stick your neck out too far on things that the membership might not like. And the membership of the Conservative Party, unsurprisingly, doesn't really represent society as a whole. In society as a whole, more than 90% of people support abortion for some reason. About 65% of people support decriminalisation. Surprisingly, the elderly, white, Middle England groups that cover the Conservative Party aren't really in that group. He's important because under the Abortion Act, he has the power to determine where women take those tablets. So it's all within his hands, which is deeply distressing for all of us, admittedly, but that is where we are. And because I don't have much time, I'd say even less time because Stephen went over, I've put everyone else on one page. It was originally many, many slides of exciting, entertaining side swipes. But we've got civil servants who are the ones that do a lot of the front work on the ground. They're the ones that put all the proposals together, that kind of negotiate between the ministers and the doctors. You've got the Royal College of Obstetricians and Gynecologists, who Stephen is from. You've got us, the British Pregnancy Advisory Service, and we've got a team of, I think now 7 people who work on external affairs, who work on campaigns, who spend a lot of our time trying to sort of really raise the issues of the women and advocate for their interests, for the people that we treat. So we're a service that has around 60 clinics around the country. We treat about 100,000 women a year. So we've obviously got a lot of experience. We've been around since 1968. So many, many years experience of what the law does mean for the women that we treat. There are also quite a lot of clinicians involved, members of both houses of Parliament, journalists. It's always good to find yourself a journalist who is happy to get involved, and the Abortion Act 1967. So the requirement there, obviously, with the licensed premises means that something had to change legally in order to get what we needed to get to carry on treating people during COVID. And we would say to carry on treating people generally in a better method than they had been for a long time. So the first sort of bit that we walked into, we'd done a bit of work behind the scenes, I think, for quite a while, working out how we could, if the law changed, provide this. And so we determined that we needed a change in the law. So we needed to ensure that clients didn't have to come to clinics anymore. Standard practice, although not strictly within the guidelines, to routinely scan every single woman that came for an abortion. And because most of those women are very early on in pregnancy, it wasn't generally an abdominal scan, it was usually intravaginal, which is obviously very distressing and really uncomfortable for a lot of women who may be as little as 6 or 7 weeks pregnant. And it's simply not necessary. It's not done in Ireland. It's not done in Northern Ireland. It's not done around the world. It's just not something. It's one of those things that grew up because the Act had been in place for so long rather than a clinical requirement. And we also needed abortion to be treated as an essential service. And as we saw with the PPE problems and equipment issues, that was something that became really, really important to us. So after we'd done quite a lot of work on that, up until, every time I look at this, I think, the 23rd of March was a really important date for us. And that was about changing the law on abortion. But I think for everyone else, they were probably more bothered about lockdown. So on the 21st of March, we managed to get some updated abortion guidance, courtesy of Stephen and his clinician friends. So that removed the need for routine scanning, which was really the start of sort of, I'd say, the march towards telemedicine. There was less of a march and more of a hurried rush, I think, before people, weren't allowed out of their house anymore. So up until this point, there had been a lot of face-to-face consultations. Most people were in the clinic and they were in the clinic for several hours. Obviously with COVID, that was just not something that could be continued. So we ended routine scanning, only scanning women when they needed it, and we moved to telemedicine, so telephone consultations. Pause for lockdown, which was a pleasant change, but did mean that we managed to get quite a lot of people calling us pretty sharpish about how on earth they were supposed to get their appointments. So with what was going on with the law, the Department of Health kept us up to date. They were doing lots of work, great, wonderful, thanks. Seemed to go through all of the bits it needs to go through the Department of Health, through policy at number 10, into the announcement grid. And the announcement grid is, a grid, but of lots of big announcements and when they come and how they're going to work and what the press is and who the lead is and who the press officer is. Once it's in the grid, it's essentially a lock, which is great. We thought we were all good. And in the morning on the 23rd, before lockdown arrived, wonderful, the Department of Health announced it. They were going to let women take mifepristone and misoprostol at home. Unfortunately, this did not last. Yeah, so this came up that evening. It was about 12 hours after it had been published, maybe less, and it included the immortal line, "There will be no changes to abortion regulations." It wasn't ideal, is what I would say. Now, this is actually a video of Matt Hancock in Parliament saying the same thing, but I'll skip over it because it goes on for a bit. But he essentially, we give him every chance possible with an MP asking a question about whether whether it was just a mistake. We thought maybe, you know, they'd screwed up the background work, that maybe they needed to go through it again, that it was going to be re-announced. Nope, he stood up and said, nope, nothing is going to change. Everything is as it is, and then sat down again. So yeah, did not take that opportunity to be reassuring. So we were deeply unhappy with Matt Hancock, is how I would describe that situation. So we work, Stephen and I mainly, and I think a lot of other people, though honestly, I got so little sleep at the time, and also I had COVID that I can't really remember. So we were essentially pushing our things into 3 different situations. We were pushing in private. So in BPAS, 23 out of our 73 clinics were shut because of staffing issues. We had unprecedented numbers of staff off sick, shielding, self-isolating, and we'd had to cancel more than 1,000 appointments. And that really needed to get to the Department of Health and to Matt Hancock. We were also still working in Parliament. The coronavirus bill was still passing through Parliament, and we were still working there on amendments to see whether we could change 2 doctors signing off, actually, on the understanding that we operate with very few doctors. And if our doctors all came down sick with COVID, which they could do because they often, you know, they work for BPAS, but they also work in the NHS and were being encouraged to work more, that signing off abortions would become essentially impossible, and you can't perform an abortion without signing it off. And the final one was pushing publicly. So one of our members of staff did a lot of work with public health individuals who've been advising the government very closely to put together a big sort of public open letter from them to say, look, sending 400 women a day to clinics is completely irresponsible, and this is exactly how COVID spreads. You need to put a stop to it. Which, quite interestingly, had an impact. So this was about 5 days later. We'd been working with a journalist at the Sunday Times, and that public health letter called the Department of Health. And that night, according to some court papers that I'll visit later, 9:45, the Department of Health emailed the Sunday Times and said, yeah, actually, we are going to grant approval, which was great because that's how we, that's how we found out. It wasn't something that they told us directly at that point. But it seems like they were, I think quite happy. And I'd like to think that maybe it was because at this point, Matt Hancock had been diagnosed with COVID and was secretly sat at home in bed somewhere going, please just leave me alone, stop asking me questions about abortion. But, we take what we can get. So on the 30th, the Department of Health issued a revised approval. Hurrah, that was wonderful. COVID recovery involved a lot of lying on the sofa, answering emails about how we'd managed to do a great thing. This went on, I think it's still in place currently. The thing is still in place, which means that since our service launched on the 8th of April, we've been providing telemedical abortions, or as BPAS calls them, pills by post. The Department of Health released some interim abortion statistics for the first 6 months of the year. So that was between January and the end of June. Nearly half of all abortions are now performed before 7 weeks. There's been a big fall in gestation by, I think, about more than a week. Waiting times for our service have fallen to about 1 to 2 days, which is down more than 50% on last year. It makes a really big difference for women, obviously, who don't want to remain pregnant. Once they've called us, they've decided that they want to, often they've decided that they want to end the pregnancy, and having to wait for a prolonged period to either have additional counselling or to access that service is really distressing. So lower waiting times, much better. And our complication rates have also fallen pretty dramatically. So that's much better for women and much better for the NHS. Unfortunately, that approval is time limited, so it can be revoked at any time. And in the midst of all of this, Christian Concern, you can probably imagine where they stand on abortion, launched a pretty ill-advised judicial review of the decision. I would really recommend, if you've got some time on your hands and you like abortion law, please read that Court of Appeal ruling, because it is vicious. It's pretty entertaining to read. Essentially, the decision about whether the government had the power to make that decision had already been done. It had already been done before in the Court of Session in Scotland. It had been upheld by the Court of Session in Scotland. Inexplicably, the Court of Appeal decided to hear the case anyway. So yeah, it was an interesting hearing and a much more interesting ruling. There's now going to be a consultation. The government, so we worked within Parliament to try and get a consultation in place in the hope that we can make this a permanent change, because it's better for the NHS as a whole, but in terms of patient experience, this is something that where we don't want to have to go back to women being forced to come into a clinic to take a pill and leave again. So it's going to be a political consultation, but it'll be public. And we really need input from clinicians, lawyers, pro-choice activists, anybody who's got any interest in providing or receiving high quality abortion services. We're expecting that to be launched later this year. And we're going to be producing a guide to responding. So, keep an eye on what's going out. And I think, it's as I said at the beginning, a really revolutionary change, one of the biggest changes to abortion law in the past 50 years, and something that we really need to work to keep in place. And that, more bubbles, the end. Yeah, all right then, I will stop sharing. I'm happy to answer any questions later, obviously. Over to Jude, I guess.
Yeah, thanks ever so much, Rachel. That's fascinating how a slice of social history can have such a huge impact on something which you've been campaigning for years. But over to Jude for the last in our series of talks, and then we'll take all questions at the end.
I'm going to see if I can share my screen as well, and obviously I'm going to totally fail. It'd be much nicer if I didn't have to, because then you could look at all my nice books, which I've gathered behind me to give the wrong impression that I actually have the slightest clue what law says. Let me just see if this works. Can someone give me a thumbs up if you can see some slides? Good on you. So that beautiful building is Doughty Street Chambers, where I now sit, where I'm a barrister. And one of my areas of practice is human rights work. And as you may know, human rights lawyers have recently come in for a wee bit of praise, because we're said to be activist lawyers. And so I wanted to start by looking at what legal activism looks like. Because as we know in the United States of America, as Stephen said, and perhaps this is why maybe some of my fellow presenters are a little bleary-eyed today, because I've been sitting up enjoying the death of civilization overnight. But as we can see there, abortion is a political issue. It's a serious political issue because the US Supreme Court established that right in Roe against Wade back in 1973. And so the ultimate goal of many people has been to overturn that decision. It's a judicial decision, and the way of challenging it is through political appointments. And here you can see the most recent appointment to the US Supreme Court in the last week or two. And her appointment was heralded by Donald Trump as saying that overturning Roe against Wade was possible. And so do we have the same thing in the United Kingdom? Well, obviously we have our own legal activists, and the government loves legal activists, as you can see. They love it so much that they're introducing about 7 different independent reviews to try and stop people from ever doing anything with law. So we've got an independent review of administrative law, we've got an independent review of the Human Rights Act, and the ultimate goal is to better balance what is called the right of the government to govern with the rights of individuals, which is not an obvious balance that many constitutional scholars will have ever drawn attention to before. But how does that impact on abortion? Do we have in this jurisdiction the same approach to litigating this issue? And I'm going to start, as you may tell from my accent, where I'm from, Northern Ireland. And you can see there, as Stephen said, the Offences Against the Person Act 1861. And it was actually written by a pleasant old gentleman called Charles Springle Greaves, QC. And you can see from its language in Noble Latin that it's really aiming at contemporary society in 2020 in the United Kingdom. And that statute remained in place in Northern Ireland until this year. It remains in place in England and Wales as well, where it's tempered by the Abortion Act 1967, as Stephen has described, which provides for various defences to these criminal offences. And so these are offences with life imprisonment: attempting to procure an abortion, having an abortion, and performing an abortion in Northern Ireland, life imprisonment. Also a very serious criminal offence in Northern Ireland, the destruction of a child then capable of being born. And where did that leave you? It meant that in Northern Ireland, it was a criminal offence to even provide abortion services to women, unless they were provided in good faith for the purpose of preserving a woman's life, or in the beautiful contemporary language, maintaining the pregnancy would leave a woman in a state of being a physical and mental wreck. And so where did that leave people in Northern Ireland? Well, before home use pills became illegally available in Northern Ireland, a survey of GPs found that 11% of GPs in Northern Ireland had seen the effects of attempts at amateur abortions. Visible injuries through knitting needles, crochet needles, sticks, wire coat hangers, any of which could cause very serious perforations of blood vessels. Women who sought the services of the Abortion Support Network, one of the NGOs that's very active in this area, had told the Abortion Support Network of how they'd swallowed packets of birth control pills, drunk bottles of gin, drunk floor cleaner, drunk bleach, taken all the available medication in their medicine cabinet, tripped themselves down the stairs, even took excessive amounts of herbal remedies. And the choice for women who didn't want to go through an unlawful abortion was, of course, to travel. And you could travel to England and Wales, but you couldn't get an abortion there on the NHS. There was around, up until recently, suggestion of around 1,000 women from Northern Ireland having abortions in England and Wales every year. And those figures were widely regarded as likely to be an underestimation because people were lying about where they were from. Abortions were expensive in England and Wales if you didn't have NHS support. You had to pay to travel, you had to pay for the abortion, you had to go through it often on your own. If you were the victim of rape or other sexual offences, you had to take the risk of going away from an area in which your abuser may be present and may know exactly where you were going. And so you might have thought that this kind of evidential situation was ripe for lawyers, activist lawyers, to try and do something about it. And that's exactly what they did. And so on the screen at the minute, you will see the various ways in which lawyers in Northern Ireland since 2004 have sought to challenge this legislation. First of all, to try and clarify the policy framework. And that's the case brought by the now sadly demised Family Planning Association of Northern Ireland, which put in place a policy framework to regulate the actual provision of abortion in Northern Ireland. Then when women and children were prosecuted for seeking to obtain abortion, including through the provision of pills online, those decisions were challenged by way of judicial review. And one of the most recent and obvious ones is the judicial review in JR76's case, a 15-year-old kid who'd conceived through alleged sexual assault. Then you had people trying to bring judicial reviews here in England and Wales. The case of a child in the Secretary of State for Health 2017 was a case in which another 15-year-old child who became pregnant came to England and Wales and wanted to obtain abortion on the NHS rather than having to pay for it. And then, of course, most famously, the Northern Ireland Human Rights Commission case in 2018. And I want to focus on the last two of those cases, not just because I was in them, and therefore those are the most important cases of all time, but also because they were in the Supreme Court and they give us a little bit of an insight into the limits of law and the limits of judicial review in this area. So in Re A child, 15-year-old girl, she becomes pregnant, she travels to England, she doesn't want to pay for it. Is that unlawful discrimination? If a 15-year-old girl from England went to get an abortion, she wouldn't have to pay for it. If a 15-year-old girl from Northern Ireland did, she would. And it's a very surprising situation, particularly when the array of evidence, which I introduced my talk with, was put before the court by five organisations, including BPAS, I'm pleased to say, who gave the Supreme Court the full insight into what the situation in Northern Ireland actually meant. But a very narrow majority of the Supreme Court, of course, Lord Kerr and Lady Hale in the minority, said that that was not unlawful discrimination, because it's not discrimination to discriminate against someone on the basis of the devolved settlement. And of course there was an outcry, but the outcry was amplified by the fact that just that very week, you had the Conservative Party doing a deal with the Democratic Unionist Party, the DUP, to try and keep the Conservative Party in power. Then you had the government trying to introduce a new Queen's Speech. Then you had a member of Parliament from Walthamstow, Stella Creasy, trying to raise issues in that Queen's Speech about this precise situation the week after the Supreme Court decision. And that particular odd combination of political events meant that the Secretary of State changed the law. And therefore, thereafter, a publicly funded system was put in place to enable women from Northern Ireland to obtain abortions in England through the NHS. So it failed as a legal claim, but succeeded through that concatenation of political events. Northern Ireland Human Rights Commission, another very important case, another case in which a group of interveners intervened to assist the Supreme Court, both from the pro-choice perspective and from the anti-choice perspective. You can see on the screen a very brave woman. Her name's Sarah Ewart. Her case was described by Lord Kerr in the judgment. It's heartbreaking. In summer 2013, just prior to her 20th week of pregnancy, a scan revealed that her baby had a very serious condition, the lack of a developed brain and skull. She was told there was no risk to her health and that the baby would be monitored fortnightly and labour would be induced. And then if it died, she would have to deliver it. And effectively, she had to live with a baby in that situation, going around her local area with people saying, congratulations that you're pregnant, knowing that your child was going to die. And Lord Kerr described her situation in the most moving terms. And eventually she, of course, travelled to England where she received the treatment, and she didn't want to go through that again. She put her head above the parapet. She's one of the few people whose names aren't anonymised in these judgments. And perhaps as a result of that, or indeed as a result of the quite stirring insistence on women's autonomy as a right, a large majority of the Supreme Court found that was a breach of Article 8 of the European Convention on Human Rights. So in those categories, fatal fetal abnormality, rape and incest, the law in Northern Ireland breached Article 8. But the case still didn't succeed because, as a quirk of legal technicalities, the Northern Ireland Human Rights Commission, who had brought the case, didn't actually have standing to bring the case in the first place. So no relief was ultimately issued. And we know now what's happened since then. First of all, as you can see, the European Union Withdrawal Agreement Act has now given the NIHRC the standing to bring this type of case, so that situation won't arise again. Secondly, Parliament, again through political pressure from the likes of Rachael, Stephen and others, introduced Section 9 of the Northern Ireland Executive Formation Act, which required the Secretary of State to introduce regulations, which we now see, the Abortion Northern Ireland Regulations 2020, which allow for the provision of some abortion services in Northern Ireland, which, and also I should stress that sections 58 and 59 of the Offences Against the Person Act were repealed as a result of these things. So again, a legal case that was ultimately unsuccessful, but that led to very practical results, again, through political pressure. What is time? It's a philosophical question, given I'm probably already over time. It's not just Northern Ireland that raises issues of abortion rights and access. This is another case which was brought this year in the Court of Appeal just before lockdown, brought by BPAS, the organisation that employs Rachael. The issue here was what the 24th week of a pregnancy means. Can you have an abortion on the 1 minute past midnight on day 23 plus 6? Or is the ultimate cutoff day 24 plus 0? And clinical practice around the world would suggest it was the latter, because day 0, as we know, is an entirely notional concept in which you're not only not actually pregnant, but it's being dated back from a date when your last menstrual period should have started, that was itself inherently flexible. But the Court of Appeal said the time is time. The time starts at midnight. A day starts at midnight and ends at midnight, and a week has 7 days in it. And therefore, the BPAS claim was ultimately unsuccessful. And it's not just people litigating to try and improve abortion access. We also know that people are litigating to try and stop abortion access. And here's the case that Rachael mentioned in devastating terms, the Christian Concern case from earlier this year. And there's the reference, it's 2020 EWCA Civ 1239, if you want to read some of that devastating learning for yourself. And what is, I think, interesting is that Nicola Davies, LJ, who gives the judgment in that case, was also the judge in the BPAS case that we've just looked at. And it seems from her insistence on the purpose of the Abortion Act 1967 being to broaden access to abortion, that perhaps some of the submissions that were made to her in the earlier BPAS case were of assistance to her in helping to dismiss Christian Concern's application for judicial review. And of course, there's more to come. And here are 2 cases which I've learned about today, which are due to be considered by the Administrative Court in the coming months. First of all, a challenge to the National Institute for Health and Care Excellence, the guidance that regulates the provision of abortion through healthcare in this jurisdiction. And here someone is saying that the guidance is incomplete because it doesn't explain the things which are set out on the screen, namely that a fetus may suffer pain, that analgesia should be administered to the fetus prior to surgical abortion after 18 weeks gestation, that there's a chance of successful survival for a fetus after 22 weeks of gestation. And a lot of these things, of course, are medically controversial. There have been numerous studies carried out, not only by experts, but also by parliamentary committees into these issues. And I understand that that's a case which may come before the court soon. Another case, the parents of a Down syndrome child and a Down syndrome adult who are calling for the removal of non-fatal fetal abnormality. So fetal abnormality that doesn't lead to death from the Abortion Act 1967. And I'm surprised to see recently that that's been granted permission as well. And of course, other cases in the last year, including the unsuccessful challenge to the buffer zone in Ealing, and a number of other cases brought by anti-choice activists. So we see that there are legal claims being brought by pro-choice activists, legal claims, including these which are coming up, brought by anti-choice activists. None so far as I can tell have actually succeeded, but many have led to positive change once the judgment has percolated into political pressure brought by other groups. And therefore, insofar as we can have activist lawyers in this country, it's a matter for you to decide whether or not any of those activist law claims have actually brought about successful change. And so that's where we end. And I'll turn now to back to Angharad so that we can deal with any questions which have popped up during these fascinating talks.
Thank you very much, Jude. And I think your talk really underlines how even though legal claims may not in their own right lead to legislative change, they obviously indirectly do so, and there is the interplay between the law and the politics. We've got a few questions. Interestingly, they've come from various different quarters, but some are very similar. And I'll just go with the first one, which is a question I also had for you, which is, do you think that the current abortion rights established through COVID are here to stay, given that it's obviously safer for women and for the NHS? I think you probably all got something to say about that, but maybe if we could start with Stephen, what do you think?
I think it comes down to what the government weigh in their decision making. We're very clear that this is safer, more effective, kinder to women who are seeking abortion care. We're compiling the data which shows improvements in terms of reducing gestational age of abortion. We know that abortion is very safe, but it's safer the earlier that it's carried out. So this, if it comes down to defining abortion as healthcare, then we would definitely expect the government to make this permanent feature. The problem is that because it's such a political issue, they could also consider other factors, such as the arguments brought by often series of mistruths brought by other groups, which we've sort of gone over in the presentation. So from my perspective, if the government is deciding on this issue based on the right criteria, then it will be made permanent. If they obviously weigh up the wrong criteria and they decide to not go ahead and make this permanent, they really will be doing a disservice to women, because, like I said, it's safer, it's more effective, it's just better all round. As Rachael said as well, the previous model is not coming back. So providers are not going to provide intravaginal scans for all women seeking an abortion before 10 weeks. It's just not going to happen. So we'll end up in a really strange situation where women are literally forced to come to a clinic to take a pill, and that will be it. It will be complete madness, I think. So hopefully the government will make the right decision.
Rachael, anything to add?
Yeah, I think that actually this question kind of goes to the heart of, I would say, the reason why I have a job, the reason Stephen has a job, which is that I think that it would be great if it was just doctors and nurses that decided what was important when it comes to abortion, but unfortunately, because of the legal situation, it's not. So I think a lot of making sure that this stays in place is about working out what messages work and what people need to hear in order to allay their fears, in order to justify it as a thing for themselves. And I think when we're talking about the government, we know that they're concerned about the outcomes for women. We know that they're concerned about safety, but we also know that they're concerned about much more basic things like the cost to the NHS, the pressures on services, at the moment, things like transmission of COVID, but also access for people who are in much more difficult situations. So women with work or caring responsibilities, women with disabilities, women who otherwise would not be able to access legal abortion. And the one thing actually that we haven't mentioned at all is the essential vanishing of illegal abortion. So because of the way that the Abortion Act currently works, or did work up until March, there was still a reasonable number of women who were accessing illegal abortion in England and Wales. And that was because those women couldn't get to clinics, that either medical conditions, work or caring responsibilities, domestic abuse issues, lack of eligibility for NHS care, all of those reasons why they may not want to present to a clinic or couldn't present to a clinic. And so we're instead going online to buy pills from reputable providers, but which obviously under the 1861 Act was a crime and they were risking life imprisonment. And since the law has changed, we've seen that disappear. And I think that that's one of those, I think this sort of combination of messages, when you're talking about not just what's good for women and not what's good for doctors, but also about what's good for society as a whole, are really important things. I think it's about talking to people in a way that they want to hear and not just what we think they should care about.
This is sort of similar, really. Somebody's just commenting on the situation in America and the pro-life makeup of some of the judiciary in the US, and whether you're concerned that abortion rights are going to regress for women over here.
Well, one of the interesting things about the judiciary in this country is that we don't really know what their political views are. We don't really know what their moral or religious views are. They aren't picked in the same way as judges in America, and that may be a very good thing, but it also ends up in quite unusual situations where you have a recently retired Supreme Court judge effectively calling on people to break criminal law in respect of the lockdown. also saying that they didn't really believe in human rights law, despite having recently given judgments in respect of what human rights law required. And it may be said that maybe a little degree of transparency in respect of what judges think will help us understand a little bit better how they approach their judgments. Obviously, there's a very real risk in America. I say that not as a lawyer, but as someone who has a dim understanding of what's going on there. The court has changed, and the recent election results mean that it's going to be very difficult for the Democrats to do anything about the change in the court. And that may very well mean that in the coming weeks and months and years, that Roe against Wade becomes an authority which is under interrogation. Will the same thing happen here? Well, as I've said in my talk, not very many of the cases in this area have actually succeeded, whether they're trying to push change forward for women or whether they're trying to stop change from happening for women. And I imagine that trend will probably continue, notwithstanding our best attempts to try and advocate.
I think slightly off topic, but we've in the legal arena, we've been fairly worried to hear of the Prime Minister and other members of Cabinet talking about left-wing activist lawyers who must be stopped. And, you know, whilst the rhetoric over here isn't quite what it is in the US, it's a moment that makes you wonder where we're going.
I think I wanted to add, if I can, sort of from a more clinical angle, I think Roe v. Wade is obviously of paramount importance in the US, but for a long, long time, lawyers for the anti-choice groups have sought to find ways around it. And that's primarily been used as something called a trap policy. So essentially trying to narrow down all of the things you are legally allowed to. So not talking about not being able to provide abortions, but saying you've got to be within a certain number of miles of a hospital, you have to be a certain size, you have to be registered in a certain way, you have to have a certain number of staff, and essentially make it impossible for those providers to provide, even if they are legally allowed to. And I think that one of the most interesting things, if you think about the difference between 1973 and 2020, is actually the development of medical abortion. Early medical abortion is not used as routinely in America as it is over here, but it now accounts for nearly 90% of all abortions in England. And it's, you know, it's one of those things that you can safely self-manage at home. Those medications are safe, they're effective, they result in a complete abortion about 98% of the time. We're not going back to a situation where women have to use coat hangers, have to use knitting needles, are at high risk of infection. We are going to a circumstance where, and I actually read this description of the Abortion Support Network group on Twitter a couple of days ago, anarchist direct action groups who are standing up for women's rights. There are plenty of grassroots campaigners in the US who understand how to provide abortions. I think the risk there is criminalization of them, criminalization of women. But what we see in America is even the worst laws, the laws that say you shouldn't, the heartbeat laws where you shouldn't have an abortion after 6 weeks pregnancy, even they don't criminalize women. We in England are in a much worse situation in that if a woman buys pills and takes pills, she's committing a crime that carries a life sentence. And that's the one thing America's got going for it, that even the anti-choice people there aren't trying to do that, which means that there is an ability for women to self-manage their own abortions at home using pills that they can buy. It would not be ideal, but I think that we wouldn't be back in the same situation we were in 1972. And of course, there are states that have passed their own laws that are much more, that, you know, protect women's right to access care. So it would mean traveling, but there are those states. It's not all states that want to completely ban it. There are states such as New York, which are providing exceptionally, liberal laws on abortion that enable women to really exercise their rights.
Thank you, Rachel. Stephen?
Yeah, I mean, it's a really interesting question, and I think I said in my talk I wanted to provide a bit of bonus stuff on this, because, you know, if I was in my position in America, I wouldn't really be confident in the way that things are going in America. If we take, for granted that Biden wins the presidency, we're still in a situation where it's unlikely the Democrats will take the Senate, and clearly we've got a new makeup of the Supreme Court. So if there is a case which really challenges Roe v. Wade and that is essentially overturned, then we will be left with states deciding abortion law. And while New York has a really progressive law, obviously other states do not. And when we're in that situation, the only thing that we could really, could there be a federal law passed around abortion care? Well, not if you don't have the Senate, then it's really difficult to achieve that, I think. So if I was in Washington at the moment, I'd be really scared about actually where things are going, because you might have a president who actually his executive power is really quite curtailed by the nature of the government over there at the moment. It's a really tricky one.
Thank you, Stephen. Back to the questions. I think we've touched on this already, but I'll read it out in case the speakers want to add anything. Firstly, the question is, thank you all very much for extremely interesting presentations, and says, what do you think providers, I presume medical providers, would do if the temporary approval order permitting telemedicine expires? Going back to the previous model would seem incredibly regressive. I think we all agree on that, but anyone have any comments?
Yeah, absolutely. So I think, given that I'm from a provider, probably the sensible one to answer this. We've been clear that BPAS will not be going back to the pre-existing model, that we were already, before the law changed and before COVID, in fact, looking at how we could change our service to ensure that routine scanning was not part of the service that we provided. Because in our opinion, it was unnecessary, it was distressing for women, it was simply incredibly out of date. So we're not going to be going back to a system of routine scanning. We've also now got quite a, it was, I think, one of those things the NHS had to do as well, build up very quickly a very large telephone consultation ability. So, clinical staff that are used to working with phones and video calls, that are able to talk to women no matter where they are in the country. And our experience of that has been that it's a lot easier to reduce your waiting times and to ensure that women can access that care. So we're going to be sticking with telephone consultation, large numbers of telephone consultations, and no routine scanning. And I think really it was Stephen that said earlier that if the law does change back, it very much is, it's a making an ass of the law, really, because the only reason that a woman would be attending a clinic in, probably more than 50% of the time would be to take a pill and leave again. And it really would be, what are we forcing women to do? How is this actually, productive and functional in terms of abortion care? But I think that we need to be really clear that the only power that the government has is to tell you where you take that pill. It doesn't have the power to tell us you have to scan women. We're not, the southern US. It doesn't have the power to tell doctors how they do their jobs. What it does have the power to do is tell you whether a woman stands inside a clinic or stands outside a clinic when she's taking one tablet. And that really is, I think, where we're down to. And I think, to be honest, the sooner the government realises that, the better.
Stephen, did you want to add anything?
I think Rachel's covered it all. I think we'd be in a ridiculous situation where, women who are eligible for early medical abortion via telemedicine would be simply asked to attend a clinic out of their often busy days for no reason whatsoever. So the providers are clear that things aren't going to go back to the way they were, which makes the consultation fairly silly, really.
So, interesting question coming up. Why is it, from a legal perspective, that women's reproductive functions are so much more heavily regulated than men's? Thinking of, for example, why Viagra is available without prescription, whilst emergency contraception is not, despite it being much safer, or, of course, abortion as a whole.
I think it's correct from a legal perspective that abortion and many aspects of women's healthcare are much more heavily regulated. Unfortunately, I've yet to advise on the human right to accessing Viagra, but I'm sure that we could try and think of some legally active things to say about it. Really, it's a philosophical question which comes down to the makeup of society, and it's difficult as a feminist to avoid the conclusion that the reason that laws are in place that regulate women's healthcare but not the equivalent things for men is because the legislature has traditionally been discriminated against women, and that's very unfortunate from a feminist perspective.
I was going to make exactly the same point, so thank you for making that for me.
I was also going to say that you might, to not offend our watchers or Stephen too much, that actually one of the interesting historical points is that it's been about doctors' lack of trusting of women as well, that the way that the law works very much used to be. I mean, when you look at old-fashioned abortion law, it very much wasn't treated as an abortion until the quickening, the point when you could feel the fetus moving, because at that point, that was the only point that essentially a woman could prove she was pregnant, I guess. And I think that as technology has developed, once you've got pregnancy tests, once you've got ultrasound scans, it's really been seen as the embryo, the fetus, having a right of itself, in and of itself, outside that woman. And I think in a lot of ways, women get written out of a lot of the discussions around this. It isn't just about abortion, it's also about things like taking medication during pregnancy. So the question of, if you've got epilepsy and the only drug that controls your epileptic fits is sodium valproate, what right do you have to continue taking that medication if you want to get pregnant, when all of the current guidance from the MHRA is that no woman should be pregnant because of the risk of fetal abnormality? And I think it is a real danger that doesn't just sit with legislation or sit with abortion, that actually the question of seeing a woman as a part and parcel of her own pregnancy and being present in the discussions and the decisions that are made has to be something that we continually try and remind people, because honestly, I sit through so many meetings where people want to talk about the rights of the rights of a fetus, the right of women that have pregnancies that don't go the way they want, but they don't want to talk about the decisions that women make about themselves that doctors or nurses may not agree with. And I think that actually that refers back to the last one of these meetings around women who don't have mental capacity, and the question of, if they want something that a doctor doesn't think is a sensible decision, what right does she have, and how is she treated because she's making what seemed to be a stupid decision? So I know I went a bit off on a tangent there, but essentially, not just law, society as a whole, everyone should care about pregnant women more.
I think it's really important there if you go back to read the NIHRC judgment, it turns on quite a difficult issue, because obviously people think that fetuses have rights, people think that women have a right, and some people try and balance those two rights against each other. But the important thing from NIHRC is that even many of the male judges, if I can be so bold as to separate judges by their gender, recognize that women have the right to autonomy to take decisions about their own healthcare decisions. And that was a submission that was made by BPAS and other NGOs in a short intervention. And it seems to have been that submission which helped to turn the majority of the Supreme Court towards a finding of a breach of Article 8. And so that's really quite a welcome development. It comes from a series of cases that were decided by Lady Hale and others in the 90s and early 2000s about personal injury cases in respect of women who became pregnant effectively, but due to negligent actions by medics. And in those types of cases, the impact on women of those types of decisions were emphasized by Lady Hale and others, and that principle that has now been brought into jurisprudence on abortion rights as well, and it's been very determinative and is welcome from my perspective.
Stephen, anything to add, or do you want me to go on to the next question?
I mean, I agree completely with both Jude and Rachael. I think it's all about informed choice, consent, and recognizing autonomy. And I agree, medicine, which has for many years operated in a sort of patriarchal way, I think has changed and is changing for the better, but it's still definitely something that we have to always challenge.
Okay, another question. I was interested in what Stephen said about the huge shift in attitudes, even comparatively recently since 2017, in terms of attitudes to decriminalisation of abortion. Have you got any insight, Stephen, into what particular strategies have borne fruit, what hasn't, or is it just a conversation in society which has informed MPs' views? What do you think?
Yeah, I think it's that. I think it's the fact that, you know, we've done quite a lot of work with MPs. Lots of MPs don't sort of understand the nature of abortion. They don't know that early medical abortion is sort of, you know, a thing really for women under 10 weeks. I also think that, you know, the case in Northern Ireland, the Sarah Ewart case that Jude talks about, had, you know, the really sad and traumatic circumstances of that case travelled, and it was clear, I think, to MPs that this is an outdated area of the law. So I think it's a combination of lots of different things, lots of different actors. It comes back really to the essence of this kind of webinar. I think it's all the changes in healthcare. So innovation, it's educating our legislators about innovation in care. It's those legal cases which really highlight the sort of the terrible situations that arise through outdated legislation and outdated law. And so I think it's a combination. What I always say is we just have to keep on working through Parliament. We have to keep on educating. We have to have round tables to discuss things. We need to do all these different things to make sure that we're sort of overcoming the stigma. We're talking openly about actually what abortion care is like in 2020. It's not 1967 anymore. Women don't have to go in for, you know, a week to have a surgical abortion. It's completely different, and it's just, I think the main thing is education. And since the RCOG voted in 2017 in favour of decriminalisation, it's really provided our organisation with the ability really to talk about the advancements we want to see. So I think that's been really beneficial too.
Rachael, Jude, anything to add?
I mean, it is kind of, as a lawyer, a lot of the time you want to protect your client from the impact of bringing this type of claim in such a controversial and often poisonous arena. And so it's for that reason that when you look back at all of the cases that I went through, the majority of them are anonymized, or they're brought by NGOs who have particular interest in this area. And I agree with Stephen that the likes of Sarah Ewart and others who put their heads above the parapet in the NIHRC case, certainly in Northern Ireland, helped to bring about a really much more meaningful discussion about what abortion was, because people could see personally the impact that abortion has on people, or the lack of abortion can have on people. And if you're ever enough of a legal nerd to watch Supreme Court TV, which some of us still do when I'm not perusing my legal tomes, of course, then you can see that Natalie Leaven, QC, who's now Mrs. Justice Leaven, a judge in family court, opened her submissions for the NIHRC with about 30 minutes just reading out the affidavits from the various women who'd come forward to give evidence about the impact of lack of abortion on them. And it's for that reason that Lord Kerr in his judgment included a lot of that detail. And I think that sort of personal side of things is not just legally very powerful, but I think it's also politically advantageous in helping people to see the reality of what these cases mean.
I think I'd just say quickly, and I guess I know somewhere close to closing, I think it's a really good example of what happens when you start going on the offensive. I think for a really long time, abortion providers and doctors were very much on the back foot. What we were dealing with was a small, dedicated, rowdy group of anti-choice politicians who spent their time trying to eke away bits of the Abortion Act, and they were never successful. In 50 years, they have never succeeded in reducing the rights available under the Abortion Act, but it didn't stop them trying. You know, you saw people trying to strip the ability to counsel women from abortion providers and instead give them to Christian organizations that are anti-abortion. You saw people trying to specifically outlaw particular reasons for abortions. You saw people trying to outlaw people accessing certain kinds of abortions. You saw repeated court cases brought by lawyers that are still active, trying to bring injunctions against individual women accessing abortions because their husband didn't want them to. And I think at some point around about 2014, BPAS said, stop. You know what, this isn't on anymore. We need to find something to rally around. We need to find something that helps women and that makes us show that abortion isn't something that has to be defended. It's something that has to be driven forward. It's something that has to be part of a liberal settlement for women's rights in this country. I think that's where the support for decriminalisation began to grow from, because it's something that until that point, it was a very much the Abortion Act is the be all and end all, and that defending that is where we are. And I think we've started a movement forward, and RCOG obviously incredibly supportive, and lots of other groups now on board with the idea that things as they are fine, but they're not as good as they could be. They are not treating abortion as healthcare. They are not treating women as equal partners in their care. And they are not treating abortion as a modern healthcare procedure that it is. And that's where we need to be. And that's why we've got to continue fighting for more and not settle for defending what we already have.
Thank you very much, Rachel. I'm afraid we're out of time. So can I thank the audience very much for all of your questions, which were fascinating. And can I also give grateful thanks to all three speakers for such brilliant talks, which really made me think. And thank you for coming, and we hope to see you next time.